Today is part 2 of our short series on disability asset protection and part 2 of 2 on supplemental needs trusts and special needs trusts. In our first part, we talked about why we have disability asset protection. In part 2, we're going to talk about what the difference is between special needs trusts and supplemental needs trusts and who qualifies for each trust. My name is Gregory Singleton. I'm an estate planning and probate attorney who works for Signature Law. Signature Law is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, please feel free to hit that like and subscribe button. It actually helps support the channel. Also, a couple caveats before we get going. First of all, these videos are for educational purposes only. They are not giving legal advice. And second of all, these videos are going to talk primarily about Minnesota law. If you're in another jurisdiction, make sure to talk to an estate planning professional in that jurisdiction before you plan your estate. So, who qualifies for special needs trusts and supplemental needs trusts, and what is the primary difference between them? Let's talk about qualifying for the trusts. We're talking about disability asset protection, and that should give you the first clue. These trusts are for individuals with disabilities, primarily who are on medical or on governmental benefits. For a special needs trust, an individual must have a medical impairment that prevents the person from participating in substantial gainful activity. This is defined under the Social Security Administration guidelines. We're not going to go into details about what that is, but substantial gainful activity is the primary test. For a supplemental needs trust, the statute we look for is you have to have a disability that meets a criteria under Title II or Title 16 of the Social Security Act, or you have to have a disability that is expected to last 12 months or longer and substantially impair a person's ability to provide for the person's care or custody. So they're slightly different. We're not going to go into too much depths about which one does which, but just be aware that there are differences. The second difference between supplemental needs trust and special needs trust is really the qualification age of when you can have such trusts. For a supplemental needs trust, they can be formed by a person with a disability, a qualifying disability, of any age, with an exception. If you're in long-term care, you must be below the age of 65 to form a supplemental needs trust. If you're over 65 and you're not in long-term care, you're fine. If you have a supplemental needs trust and you go into long-term care, then we have to ask a question. If you're in an institution for more than 6 months and have no reasonable expectation of discharge, then the supplemental needs trust becomes unenforceable. This means that the assets become available. If you remember from last video, if an asset is available and you're trying to meet the impoverishment requirement, you're going to have to do a spend down of your assets until you are below the asset maximum. For a special needs trust, it's slightly different. Generally, they can be formed by a person with a disability who is under the age of 65 years old. If you're over 64, you cannot establish. However, if you already have a special needs trust, you can still access the special needs trust. And it doesn't matter if you're in long-term care or not. That doesn't matter for special needs trusts. So we're starting to see a few differences between special needs trusts and supplemental needs trusts. I've saved the best for last. Let's look at the primary difference between a special needs trust and a supplemental needs trust, and that difference is where the money comes from. For a special needs trust, the money is going to come from primarily the individual with a disability or their spouse. Now, it can also come from a parent, a grandparent, a legal guardian, legal conservator, or a court, but primarily it's going to be assets from the individual with the disability or their spouse. A supplemental needs trust, however, must be third-party funds, not money from the individual or their spouse. Commonly, these are created and formed and funded by a grandparent or a parent, oftentimes in a will or revocable living trust. The key for a special needs trust and supplemental needs trust is finding out where the money comes from. So here's the scenario. Take Bob, my favorite guy. Bob has a disability and he's going to be inheriting from his grandmother. Bob qualifies under medical assistance. He meets all the qualifications for both a special needs trust and a supplemental needs trust. His great uncle dies, leaving him $200,000. So does it get left in a special needs trust or a supplemental needs trust? Well, money comes from a great uncle. The money was left to him, to Bob, in a will, but notably the money was not left directly into a trust. Since the money was left directly to Bob and not put in a trust for Bob, the only trust that it can be put in is a special needs trust. Because once Bob received the money, it's his money. It cannot be put into a supplemental needs trust, which must be funded by a third party. So here's the other big difference between special needs trust and supplemental needs trust. A supplemental needs trust, in a supplemental needs trust, the beneficiary is selected by the settlor, the person who forms the trust. They decide who the beneficiary is, which will be the person with the disability, and who the successor beneficiaries are. It can say, for instance, it can have a contingency. It can say it goes to Bob, and when Bob dies, he'll still have the trust. Then the settlor will decide that the funds will go to Bob's children or spouse or siblings or whoever. Bob doesn't get to choose that, but the settlor gets to make that decision. For a special needs trust, the settlor can still make that decision. However, the government has the right to seek reimbursement for all medical bills paid through the government benefits. So the settlor can say it goes to Bob, and then after Bob dies, it goes to Bob's children. The government says it goes to Bob, and then when Bob dies, I'm going to come in and get reimbursement for all benefits paid to Bob. And not just all benefits paid to Bob since the creation of the trust, all medical benefits paid to Bob throughout Bob's life. So realistically, for a special needs trust, the government's going to get all the residuary. Now, for a supplemental needs trust, it will go to the beneficiaries selected by the settlor. What does this mean? It means that a supplemental needs trust is essentially an estate planning tool. We create supplemental needs trusts in wills and in revocable living trusts to funnel money to supplement the lifestyle of an individual on a disability, and then to transfer the money to whoever we want to be the following beneficiaries after that. For a special needs trust, it usually means that the individual with a disability has assets, wants to use those assets to supplement their lifestyle without spending them down, puts it in a trust, but then those assets do not pass to the next generation. The result of this is that most estate planning attorneys will do supplemental needs trusts, not all of them, of course, but special needs trusts tends to fall outside the gambit of what most estate planning attorneys do. And you need to find an attorney who does disability law or elder law to do a special needs trust. So that's part 2 of special needs trust and supplemental needs trust. I hope you liked today's video. If you did like today's video, please feel free to hit that like and subscribe button. Again, it helps support the channel. We do a new video every other Wednesday, so you can look forward to that. We're going to be doing a few videos on disability asset protection. So if that interests you, that's fantastic. If not, you can look at some of the other videos that we have online. If you have questions, leave them in the comments below or send me an email. Otherwise, until next time, this is Gregory Singleton with Signature Law.